Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and meticulously review and edit all of the output. In today's episode 8, we're providing an even more granular look at the conclusion of Part 1, Application of the Sunshine Law. We'll be navigating pages 56 through 58 of your manual, dedicating significant detail to the general principles of sunshine law exemptions and a thorough overview of enforcement and penalties. Because we're covering these topics with extra depth, this episode will be longer than our usual 15 minutes. Let's start by talking about those moments when public meetings might not be entirely open and the incredibly strict rules governing those exceptions. Segment 1. General Principles of Sunshine Law Exemptions, pages 56. Starting right on page 56, we delve deeply into the general principles of sunshine law exemptions. After all our discussions about open meetings being the absolute rule, it's critically important to understand the exceptions. The primary principle here is crystal clear. Any time a public meeting can be closed or held in private, it must be explicitly authorized by a specific state statute or a provision within the Florida Constitution. This isn't just a guideline, it's a legal mandate. Public bodies, officers, or employees cannot simply decide to close a meeting for reasons of convenience, perceived sensitivity, or a general desire for privacy. Without a clear legal basis, the meeting must be open to the public. The legislative intent behind the Sunshine Law is overwhelmingly in favor of openness. When the legislature considers creating an exemption, they are typically trying to balance the public's right to know with another compelling public interest, such as protecting ongoing criminal investigations, sensitive negotiating strategies, or individual privacy. However, this balancing act consistently leans towards transparency. The Florida Supreme Court has consistently and emphatically reinforced this. They demand that any exemption from the Sunshine Law be narrowly construed. This phrase, narrowly construed, is fundamental. It means courts interpret these exceptions very strictly, allowing them to apply only in the precise circumstances and to the exact extent that the legislature or Constitution intended. They are not to be expanded by implication, by analogy, or by a broad reading that might unintentionally cover more situations than intended. The underlying goal is always to safeguard the public's right to access as broadly as possible. For instance, in City of Dunedin versus King, 635, Southern 2nd, 128, Florida 5th District Court of Appeal, 1994, the court reiterated that exceptions to the Sunshine Law are to be strictly interpreted to give the broadest possible application to the statute. This isn't just about what's in the exemption, but also what's not in it. This strict construction principle has several vital implications for how public bodies operate. First, specificity is paramount. If a new exemption is created, the legislature must draft it with extreme precision about what it covers. It must define the specific type of meeting, the exact information or circumstances that allow for a closed meeting, and often the procedural safeguards that must be followed. You won't find general, vague exemptions that could be applied to a wide array of different situations. This precision ensures that exemptions are not misused. Second, the burden of proof always falls squarely on the public body that is trying to keep a meeting closed. They can't just assert that an exemption applies. They must be prepared to demonstrate, often in court, that all the conditions of the claimed exemption have been met and that the meeting or portion of the meeting strictly falls within its narrow scope. If they can't prove it, the meeting is presumed to be open. Third, the principle of surgical precision in applying exemptions means that even when an exemption does allow a portion of a meeting to be closed, the remaining parts of the meeting that do not fall under the exemption must still be open to the public. For example, If a public body is discussing an exempt topic but then moves to a non-exempt topic, the meeting must immediately become open again. The goal is to maximize openness wherever legally possible. This general principle serves as a critical gatekeeper, ensuring that the spirit of the Sunshine Law, which is broad transparency and accountability, remains intact. Unless a specific, narrowly defined statute or the Constitution clearly states an exemption, the meeting remains open to the public. It's a continuous balancing act, always favoring public access unless a compelling, legally defined reason dictates otherwise. The public's right to participate in and oversee their government is seen as paramount. Segment 2, Common Categories of Sunshine Law Exemptions, detailed overview, pages 56 to 57. Continuing on pages 56 and 57, the manual provides an overview of common categories where the Sunshine Law might have an exemption. Remember, these are not blanket allowances, but rather specific examples of types of discussions that could be exempt, always under very specific, detailed statutory provisions and with procedural safeguards. One of the most frequently discussed and sometimes misunderstood exemptions involves attorney-client privilege discussions. This is explicitly found in Section 286.011, subsection 8, Florida statutes. This exemption is highly specific and applies only when a public board is meeting with its attorney to discuss pending litigation or settlement negotiations to which the public body is currently a party. The essential purpose is to allow the attorney to advise the board confidentially on legal strategy, much like a private client would receive confidential legal advice, without that advice immediately becoming public knowledge and potentially undermining the public's position in the litigation. However, this private session comes with very strict rules. The entire private meeting must be recorded verbatim by a certified court reporter, and the transcript of that meeting is confidential until the litigation is concluded. Once the case is over, that transcript typically becomes a public record. This ensures that while the immediate discussion is private, there is an eventual public record of what transpired, serving the dual goals of protecting legal strategy and maintaining ultimate transparency. The intent is not to hide public business generally, but to protect the public's direct financial and legal interests in ongoing legal disputes. This exemption does not cover general legal advice, policy discussions, or simply avoiding public scrutiny by having an attorney present. Another area involves certain strategy sessions related to collective bargaining. As we briefly touched on in Episode 6, these are narrowly defined exceptions that allow the chief executive officer, like a city manager, school superintendent, or their designated representative, to meet privately with the legislative body, like a city council or school board, to discuss specific collective bargaining strategy. This is provided for in Section 286.011, subsection 8, Florida statutes, and for state departments in Section 110.201, subsection 4, Florida statutes. The rationale here is similar to litigation strategy, to prevent the public body's bargaining strategy from becoming public knowledge, which could severely undermine their negotiating position against a union or employee group, potentially costing taxpayers more money. However, it's a critical distinction that the actual bargaining sessions with the union or employee representative must be public meetings. This exemption is for internal strategy discussions only, not for the negotiations themselves. The manual also alludes to exemptions related to real property negotiations. While not all discussions about government property are exempt, specific narrow carve-outs exist for certain negotiations for the purchase or sale of real property, and these are often designed to prevent speculative increases in land prices or to allow the public body to negotiate effectively without the market being influenced by public knowledge of their exact intentions, e.g., if a city wants to buy a specific parcel, announcing it publicly beforehand could drive up the price. These exemptions are typically temporary and require that details of the negotiation and often the full transcript of any closed session become public once the transaction is complete, or once the negotiation fails and the property is no longer being considered. The specifics are usually outlined in statutes related to land acquisition or economic development, and they always carry conditions such as requiring public notice of the intent to hold such a closed meeting and documenting the discussions for later public release. These are tailored to protect the public's financial interests in specific transactions. Finally, the manual mentions security exemptions. It's crucial to understand that this is not a broad allowance for any meeting concerning security. Instead, specific narrow statutes may exempt portions of meetings that would reveal a confidential security system plan, an emergency response plan, or similar sensitive information that is already classified as confidential under other statutory provisions. For example, Section 119.071, subsection 3, paragraph A, Florida statutes might classify certain security system plans as confidential. If a meeting would expose such confidential information, that specific portion might be exempt. The purpose is strictly to prevent disclosure of information that could directly compromise public safety, critical infrastructure, or sensitive government operations. Again, these are highly specific exemptions, and the burden is on the agency to prove that the information discussed truly falls under these narrow confidentiality rules. They often require the closed session to be recorded, with that record becoming public once the security risk is mitigated or the information is no longer sensitive, if ever. These common categories highlight the legislature's careful balancing act, protecting specific vital public interests that could be harmed by immediate disclosure, while overwhelmingly prioritizing the fundamental right to transparency. Each exemption comes with its own set of conditions and limitations, preventing them from swallowing the foundational rule of open government. The general principle remains open until proven otherwise by a specific law. Segment 3, Sunshine Law Enforcement and Penalties, detailed, pages 57 to 58. Finally, on pages 57 and 58, the manual provides a detailed overview of sunshine law enforcement and penalties. This is where we examine the serious consequences for violations and the various mechanisms available to ensure compliance. The sunshine law is not merely advisory, it carries significant legal weight designed to ensure accountability. First, let's delve into civil actions. If a public body conducts a meeting in violation of the Sunshine Law, any affected citizen, taxpayer, or even a news organization has the right to go to court to challenge that action. The primary civil remedy is the ability for a court to invalidate or nullify decisions made at an illegal meeting. This means that if a vote or any official action was taken during a meeting that violated the Sunshine Law, for example, a secret meeting, a court can declare that action voidable. The City of Daytona Beach versus Del Percho, 476 Southern 2nd, 1142, Florida, 1985, case is a seminal ruling that affirmed this powerful tool of nullification. It established that actions taken in violation of the Sunshine Law are indeed voidable by a court if a violation is proven. This is a very powerful deterrent, as it means decisions made behind closed doors can be legally undone, forcing the public body to potentially redo the entire process in the open. Beyond simply voiding actions, courts have other civil powers. They can issue injunctions, which are court orders requiring public bodies to comply with the Sunshine Law in the future, prohibiting them from holding further illegal meetings. They can also issue declaratory judgments, which clarify what the law requires in specific situations, providing guidance to public bodies and the public alike. These judicial remedies are critical not just for punishing past violations, but for ensuring ongoing compliance and for clarifying the law's application in complex scenarios. The intent is always to bring future actions into compliance with the law. Next, we address criminal and non-criminal infraction penalties. The law provides for direct consequences for individuals who violate the Sunshine Law. Section 286.011, subsection 3, Florida statutes specifically states that any member of a board or commission who violates the provisions of that section is guilty of a non-criminal infraction. This is a civil penalty, typically punishable by a fine not exceeding $500. It's often handled much like a traffic ticket, but it still carries a formal finding of a violation. This applies to less severe violations or those where intent to violate is not necessarily proven. However, for more severe violations, particularly those where a person willfully violates the Sunshine Law, more serious charges can apply. A willful violation implies a deliberate, intentional disregard for the law. Such willful violations can sometimes lead to misdemeanor charges, which carry potential jail time and larger fines. This demonstrates the seriousness with which the state views intentional efforts to circumvent transparency. These criminal penalties serve as a strong deterrent against deliberate secrecy and send a clear message about the importance of open government. Lastly, a crucial and often litigated enforcement mechanism is the provision for attorneys' fees and costs. If a citizen or organization successfully challenges a Sunshine Law violation in court, the court can, and often does, award reasonable attorneys' fees and costs to the prevailing party. This provision, found in Section 286.011, subsection 4, Florida statutes, is incredibly significant. It helps level the playing field, making it financially feasible for citizens to act as watchdogs and pursue legal action when a public body acts illegally. Without this provision, many citizens might be deterred from suing due to high legal costs, even if they have a strong case. The intent behind this specific statutory provision is to encourage enforcement by empowering private citizens and organizations to uphold the public's right to open government without incurring prohibitive personal financial expense. It recognizes that enforcing transparency benefits the entire public, not just the individual bringing the lawsuit. In summary, the Sunshine Law is backed by robust enforcement mechanisms, including the ability of courts to invalidate illegal actions, the imposition of civil and criminal penalties on individuals, and the critical provision for attorneys' fees to encourage enforcement. These provisions collectively ensure that Florida's commitment to open government is not just a lofty ideal, but a legally enforceable reality, promoting accountability and transparency in public decision-making. This concludes our comprehensive look at the Sunshine Law, bringing us to the very end of Part 1 of the manual. Thanks for listening. In our next episode, Episode 9, we'll begin our comprehensive exploration of Part 2, Public Records, starting on page 59 with the scope of the Public Records Act. Until next time, remember, the truth dies in the dark, so let's leave the light on.